Good morning friends, Namaskar, Sat Sri Akal and Adab. This is my 221st video in continuation to the consultation taken and the charges and expenditures incurred. So now here we are on a stage where the notice has been issued to us, the notice decision and a wise decision has already been made that Mr. Das, with your consultation we will make the reply of the notice, which I have already briefed in one of my videos. What will be the expenses to just make a reply, RTIs and everything on a notice. Now from this notice, the department is going to finally come up with a PP Act notice, which I have been always telling. If it is a resumption case, it will come under 4.1 and 5.1. If it is of something called constructions, it could be in 5A and 5B. And if it has to be demolition, again it will be on the similar. Eviction sometimes even is of temporary tenants in the premises, that is in 3.1. So these PP Acts will be done in 3 courts, either station headquarters or the Defence Estate Office or the Cantonment Executive Officer. So we've already made replies, the expenditure has already been done by the residents. This is his now step 4. From Janampatri he is moved gradually to the State Court. Now the PP Act is initiated. Within limitation, what has already been explained in a video, he must make the reply to this PP Act notice. So what is the department going to now expect? Mostly what the bungalow owners do, they do not reply, or even if they reply, they physically tend to attend the state court without realizing that this is the lower court. And now the DO there is not the Defence Estate Officer, he is the State Officer. So to make a reply of this notice, I would be charging minimum 1.5 lakhs. This notice the amount could rise depending on the kind of volume of the notice. If it is a resumption notice, if it is a recovery of leases, then it could be a little higher. So the oral arguments for the same reply in the state court would be approximately 50,000. Now in the state court we will move applications for production of documents, for non-production, for even admission of some documents which may be in our hand. Those various RTI letters which we had already filed, and by now time we would be getting their appeals and their answers into that. If there has been no answers, we will ask for all those documents, production of documents in the state court. Now let's say the Defence Estate Officer or the CEO of the station cell finally replies to the notice reply what we've done in the state court. And if they do not do it, we will still file a replication to the entire finding and the culminations of what happened during this process. To make that replication, I would be charging 1.5 lakhs. Final arguments will be costing 20,000 rupees. The same argument has to be tendered in writing also under the CPC. I would charge 50,000 rupees. So your total expenditure would be approximately 5.2 lakhs in the state court, which you would be paying me. A minimum amount to be paid in advance is 3 lakh rupees. Again, the expenditure for typing, for any RTIs or appeals to be made, or the local advocate who would be placed in, would be all done at an actual expense by the resident directly. That's not added in this. So roughly in the state court, he would be spending about 6.5-7 lakh rupees. And on that amount of expenditure, the resident would know a lot about his case, and I believe he would be quite educated by now. So I hope friends this makes it more clearer and transparent that this is how at present we are working. These figures, these expenditures would change onto the time period of the happening. Thank you. Good day.